Good day. My name is Mike Markowitz. I'm an attorney located in Nassau County in Hewlett, New York. For the next 6 to 7 minutes, I am going to give you an overview, very brief overview, concerning landlord-tenant law. If it looks like at any point that I'm reading, I probably am, because again, I want to be quick and informative. So this video is to give a brief overview concerning landlord-tenant law in Nassau, Suffolk, and New York City region. This video is intended to give general information to the viewer. This video is not intended to give legal advice, nor should the viewer believe that it constitutes an attorney-client relationship with me or my office. For specific questions or to retain my services, you may either email me at attorney@mampc.net. That's attorney@mampc.net. Or call me at 516-295-9061. This video is being published in April of 2020 and includes a law set forth in the Housing Stability and Tenant Protection Act of 2019. All right, so let's start. An eviction proceeding is also known as a summary proceeding. Generally, there are two types of summary proceedings: a non-payment proceeding and a holdover proceeding. A landlord files a non-payment proceeding for rent owed by the tenant. A landlord files a holdover proceeding to obtain possession of the apartment. Prior to starting a non-payment proceeding, a landlord must first give a 5-day notice to the tenant that he or she owes rent. Generally, this is delivered by certified mail. It does not have to be return receipt with that little green envelope. The landlord must serve a 14-day notice after if the landlord doesn't receive any money from the certified letter. Service is a formalized or statutory method of delivering the notice. The notice must set forth how much rent is owed, when it must be paid, and what happens if rent is not paid. Essentially, that you'll start an eviction proceeding. Prior to starting a holdover proceeding, a landlord must serve either a 30, 60, or 90-day notice on the tenant. A 30-day notice is served if a tenant has been in possession of the apartment for a period of less than 1 year. If over 1 year, a 60-day notice is served, and if over 2 years, a 90-day notice is served. The notice must set forth a specific expiration date and what happens if the tenant does not vacate the apartment. Again, that you'll commit an eviction proceeding. A summary proceeding is commenced by the filing and service of a notice of petition and petition. Depending on the location of the apartment, the summary proceeding may be commenced in a district court in Nassau, Suffolk County, or in a civil court in the city of New York. In district court, the notice of petition sets forth the date when the landlord and tenant must appear in court. This is called the return date. The return date in the New York City Civil Court depends on whether the landlord commenced a non-payment or holdover proceeding. For a holdover proceeding, the notice of petition sets forth the return date. For a non-payment proceeding, the clerk schedules a return date after the tenant files his or her answer to the petition. A conference is generally held on the return date of the petition. During the conference, issues are discussed for the purpose of the landlord and tenant entering into a settlement agreement or a stipulation of settlement. If the tenant fails to appear on the return date, the matter is scheduled for an inquest. An inquest is a hearing for the court to determine if it should award a judgment of possession and warrant of eviction. A warrant allows the county sheriff or a city marshal to enter into the apartment and actually remove the tenant. District court generally holds its inquest on the return date. New York City Civil Court generally holds the inquest on a future date after an additional notice is sent to the tenant. If the tenant appears and the parties are unable to settle the matter, the court generally schedules a trial on a future date. During the trial, the landlord must prove that 1. He or she owns the property. 2. The tenant is in possession of the property. And 3. Proper notice has been given to the tenant. And 4. That the tenant failed to comply with the notice. For example, paying the rent or vacating the apartment. Once the landlord meets his burden of proof, the tenant has the burden to prove his or her defense. There are several types of affirmative defenses. Some examples are payment. The landlord violated the warranty of habitability, which, by the way, is that the apartment is habitable, that there are no leaks, that it's not bug infested, things like that. Another example of an affirmative defense is if the apartment is illegal. However, an illegal apartment will not stop an eviction, just, in certain jurisdictions, stop a money judgment in favor of the landlord. Once a landlord receives a judgment of possession and a warrant of eviction, he or she must use a sheriff, which is again in Nassau County, or a marshal in New York City to remove the tenant. For a money judgment, a landlord should obtain a transcript of judgment and docket the judgment with the clerk in the county where the judgment was obtained. So, this again was a brief overview of landlord-tenant law in Nassau, Suffolk, and New York City region. And for more information, you may either email me at attorney@mampc.net or call me at 516-295-9061.